Welcome, we're back. How are you today? I hope you're doing fine, and we'll continue with our lectures. We now go and have a look at part 7, which is a continuation of analytical techniques for fact-centered questions. As I mentioned in the previous lectures, almost 80 to 90% of all the bar questions are fact-centered questions, and therefore you must master the manner of analysis. That's why you will see there are a lot of examples here. After having seen all the examples, I hope you try to answer the questions using the techniques you have learned. It's only in that manner that you'll be able to learn the techniques and master them for yourselves. Let's look at another example now. And this is the answer of Enrique Estrellado, a well-known lawyer in the 50s. He obtained first place in 1934 and obtained 95% in criminal law. So, since the problem is long, we'll have to go to the bottom of the problem to find out what the examiner wanted when he gave the exams. So, have this. The question at the bottom of the problem is what crime has been committed? I would like you to remember that it's difficult to answer this question if you're not familiar with all the felonies that are normally given in the bar. Let me remind you again, not all of the felonies that are listed in the revised penal code are given in the bar. They're popular areas. So when you reach the module on criminal law, try to determine the pattern and master the elements of the felonies that are very popular in order for you to be able to answer problems of this character. So therefore, as you are looking at the problem, factual setting, try to remember the elements of the various felonies in relation to the factual setting. And I'll try to do that and explain to you how when we have a look at the factual setting. Let's go back and have a look at the factual setting. So, A leaves his automobile parked on Calle David by the Hickok building one night and goes to the Lyric Theater. There's no relation at all to solving the problem. B, seeing the unguarded automobile in a dark and unfrequented street, decides to steal the spare wheel and tire, which is securely bolted and locked. So you notice now that there is taking of personal property without the consent of the owner. So in these instances, there are only two things that should come to your mind. Is this theft or is this robbery? So you try to remember the elements of theft, you also try to remember the elements of robbery, and try to find out if there is any application to the problem. So we'll see. So just analyze silently. We first tried false keys to open the lock, but failing in this, failing in this, cut the bolts by means of chisel and hammer, and took away with him the spare wheel and tire of his automobile and sold them. Question: what crime must be committed? The knee-jerk reaction here is that since there was violence as a result of cutting the bolts by means of chisel and hammer, then this is robbery. But let's find out how Estradados answered it, and let's see whether our hypothesis is correct or not. A has committed the crime of theft. So notice, he's using here the ideal answer. You have a conclusion, you have the black dot rule, and then you have the interviewing. But surprisingly, why did he say that theft was committed instead of robbery? When you have seen that there was in fact force upon things because the bolts were cut by means of chisel and hammer. Let's find out. By the way, he is correct here. I would like to remind you that all taking of property with violence is robbery, as you shall find out in this explanation. Any person who with intent to gain shall take personal property without violence or intimidation on persons or force upon things belonging to another without the other's consent is guilty of theft. So he knows that theft should be without violence or intimidation. But just the same, let's continue with this reasoning process. It is true that in taking the spare wheel and tire, B used first a false key, and failing in this, used chisel and hammer, thus applying force upon things. But this fact cannot qualify the taking away of the wheel and tire as robbery. The use of false key as a qualifying circumstance applies to entrance to a building. B never entered any building. Nor does the use of force here qualify the act as robbery. B did not enter any building, neither did he break wardrobes, chests, or close receptacles in a building. The crime committed here is theft. Notice he must conclude, because his explanation was very long, it's possible that the examiner might have forgotten everything that he has read. So, moral lesson, things are not what they seem. Analyze deeper and master all the elements before you commit to write your answer. Now, let's have a look at fact-centered questions now, which is role-playing. So the ones I've seen were fact-centered questions, uh, looking for something else, trying to test your ability, whether or not you know how to apply the elements. This time, this is role-playing. You're supposed to play a role, and consequently, your answers should play the role you're being asked to do. So if you've been assigned as the prosecutor, you do not discuss those for the defense. You only discuss those for the defense in order to overcome them. So be careful. You are the prosecutor, you are the judge. You know what a judge should do, you know what a prosecutor should do, you also know what the defense counsel should do. So with that out of the way, let's have a look at the procedure for analysis. So as usual, if the question is long, read the question at the bottom of the problem. What are some usual questions at the bottom of the problem? So, if you were the judge, will you grant Tina's motion to declare Carlos in the fault? If you were the appellate court justice, would you sustain the conviction upon appeal? What answer would you give if you were the Secretary of Labor? If FCC hires you as lawyer, what defense of defenses would you set up in order to resist the expropriation of the property? As private prosecutor, how will you dispute the veracity and accuracy of the results of the evidence? Is the court correct in dismissing the petitions for adoption? If you were the counsel for Alan de Malasuerte and other litigants whose marriages have been improperly and finally annulled, discuss your options in administrative proceedings against Judge Contaminado. If you're the ombudsman, what charges will you file against City Engineer A? If you're the labor arbiter, how will you decide the case? As counsel for ABC, or ask for advice on whether or not to grant the instruction of PJ, what will be your advice? Would your trial prosecutor impose objection to the question of the defense counsel? Explain. Now then, the next step in the analytical process is to read the problem, bearing in mind what the examiner wants as shown at the bottom of the problem and the role you're supposed to play. Afterwards, identify and if possible, underline the relevant facts. By the way, before you underline and before the start of the examination, you ask your proctor whether you could write on the questionnaire. Why? Because sometimes the proctors have different instructions. Some allow you to write, some do not allow you to write. But why do I ask you that you should now first request and ask the proctor before the start of the exams? Because if you're underlining and suddenly the proctor taps your shoulder and tells you could not do so, then your train of thought is going to be lost. That's why at the beginning, request already what is the instruction insofar as underlining and writing on the question is concerned now. And the issue, why must you underline the relevant facts? I told you before that the longer the problem is, the more is the possibility that the exam is trying to confuse you by putting in a lot of facts that have nothing to do with the solution to the problem. And therefore, you underline only the relevant facts. Afterwards, you identify the legal issues raised by the relevant facts in the right of the question raised at the bottom of the problem. Then they call the correct legal rule to apply to the legally relevant facts in the resolution of the issue. As usual, visualize the letter of the answer, begin the answer with the conclusion if warranted, reason out your answer to matching of the key facts with each element of the legal rule. And if appropriate and time is available, add your legal reasoning to the use of applicable legal policy principles. And as usual, you review your answer for missing words, misspelled words, and grammatical errors. Now, let us have a look at examples on role playing and how you're going to approach them using the techniques that you have learned. So as usual, I have my problem here. So, problem is long, and consequently, what are you going to do, and what is the role I'm supposed to play here? So, at the bottom, as counsel for Maria, what would you advise her to do? Justify your advice. Now, remember, as counsel, you're supposed to do everything that's favorable to the client within legal bounds. It's not always that you advise the client to sue. What is that which is most favorable? So you look at my answer and try to analyze carefully how I approach it. And it's funny, and the examiner here was my friend. I didn't know that he was the examiner. But afterwards, when I saw him and showed to him my notebook where he gave me a high grade, he said, May I suspect, he said, that this person is a former personal manager. And true enough, I held positions in financial administration before as head of HR, human relations. I also was head of my manufacturing division. I was operations manager and other similar character. So he said he was pleasantly surprised because my answer was the only kind of answer he saw. That's why he was very happy. All right, let's look at my answer now. I said, before we look at my answer, let's now analyze. Remember the issues as counsel, what should be my advice to the client, Maria Banting. So we're looking at here, illegal termination again. Maria Banting, a weaver in the textile plant, has served the company for 16 years. So remember the 16 years. Last year, the company awarded her a prize for being a model employee. Under retirement provision of the collective bargaining agreement, an employee who has rendered at least 15 years of continuous service has the option to retire and be entitled to gratuity pay equivalent to 1 month pay for every year of service. So she's retirable. Retirable, and notice the retirement privilege is part of the collective bargaining agreement, part of the economic provisions. And we recall, therefore, that if the economic provisions are violated, that is considered as unfair labor practice. So as you read the problem, you try to recall very, very fast what are the appropriate laws that would find into play. One day on dismissal time, Maria was caught by the security guard at the gate with a meter-long piece of cloth worth 50 pesos. Under company rules, stealing company property is punishable with dismissal. The company notified her of her termination effective 1 month later. Maria, on the other hand, applied for retirement under the CPA. After a while, the company offered Maria a compromise. The company would not terminate her employment and instead allow her to retire, but her gratuity pay under the CBA would be reduced to 15 days pay for every day of service as a punishment for infraction of the company rules. So as Councilor Maria, what would you advise her to do? Justify your advice. As counsel for Maria, I would advise her to appeal to the humanitarian and charitable character of the company, pleading in way mitigation for defenses committed, her long, exemplary, loyal, and faithful 15 years service to the company. She should be allowed to retire with full pay. So you notice, she has to plead. Do not sue first. Try to find or exhaust all avenues before you sue or avenues of mutual settlement. Because if you sue, it will take a long time for the resolution. By the time perhaps either you or Maria will be dead by the time there's finality of judgment. So take note of that. Now, she should plead that her misdeed should not be punished with just a reduction of her gratuity pay. Take note now. Failing in her plea, Maria now is at a quandary because the company denied her claim. Maria should insist on the retirement with full payment under the terms of the CBA. I would advise Maria that the company is duty bound under the penalties provided for unfair labor practice to follow the CBA and give her due under the agreement. Should the company still refuse, I would advise Maria to seek the assistance of the union in making the company comply with the CBA provisions, including resort to conciliational, mediational efforts of the Bureau of Labor Relations, the Labor Arbiter, the NLC, and if need be, a noted strike for unfair labor practice, and ultimately strike. Should an unfair labor practice be proven admissibility, then the prosecution would even ensue. Remember the agency that I was referring to? Uh, Under current rules, has nothing to do with illegal termination. The Bureau of Labor Relations here is charged with labor relations in short, union matters, etc., but not termination. So take note of that. Now, also, you would notice that I did not advise the client Maria to sue. Why? What is the company afraid of? A suit or a strike? Of course, the company is afraid of a strike. So therefore, that's what you're going to do. And also, you will notice that you are also threatening it a criminal action instead of an action merely to recover the unpaid retirement of Maria. But the answer is very long. There are 4 slides. And as I mentioned to you before, I write very fast, and you might not be able to write as fast as I could, but you could practice and able to master it. That will be an advantage for you. So there are 4 slides, and let's reduce it. How then would our modified answer look without removing the flavor of the answer? As you have noticed, my answer was very long. But I said if you're able to write very fast, then I suggest you adapt a long answer. However, since we said we want to shorten the answer, let's look at how I was able to shorten the answer. Let's look at this one now. So this is my modified answer. This is not what I wrote in the bar. This is the modified answer which suggests you should use whenever you're confronted with a similar question. I would advise her to plead that her misdeed should not be punished with a reduction of her gratuity pay. Filling in her plea, I would advise Maria that the company is duty bound, under the penalties provided for unfair labor practices, to follow the CBA and give her her due under the agreement. Should the company still refuse, I would advise Maria to seek the assistance of the union in making the company comply with the CBA provisions, including resort to conciliational, mediation efforts that Bureau of Labor Relations, the labor arbitral NLC, or if need be, an authority strike for unfair labor practice. So currently, you don't have to include anymore the Bureau of Labor Relations because you said the BLR doesn't have any jurisdiction here. And ultimately, strike. Should an unfair labor practice be proven admissibility, the next prosecution would even ensue. We have reduced it from 4 to 3 slides. And that's the end. And that's the end of part 7, which is a continuation of analytical techniques for fact-centered questions. As usual, let's take a break. Enjoy your break. And after the break, we'll discuss part 8, the last part of this module. And after part 8, we'll have to take a rest and try to determine whether we'll be able to have a look at the other modules.